My name is Kit
Yeah.
Needham. I'm the director for Project Olympus, the startup incubator for CMU, assistant dean for entrepreneurship initiatives. And we work with student, faculty, staff, alumni, explore the commercial potential of their ideas. We are partner on this series. This is the last for the semester. We've been doing this for a long time. I don't know if we're into double digits yet on number of years, but I'd like to introduce my my counterpart, my partner, Stephanie. Do you want to introduce yourself?
Sure. My name's Stephanie Dangle, and I'm a professor of practice at Pitt Law School, where I teach a number of courses related to innovation and entrepreneurship. So we're great to be partnering here. And then I'll hand it off to one of our regular partners, David Lehman, who's with a firm I practiced with many years ago. Go ahead, David.
Well, I'll let, why don't I pause for one moment and go back to Kit? If Kit, you want to
Okay.
do your thing?
What I'd like to do is, Ryan, I think you want to introduce yourself and maybe in proxy introduce Rhonda, who will be joining us when she gets off of her emergency meeting.
Sure. Good evening, everybody. My name is Ryan Skelton. I'm an administrator for student programs and operations at the Big Idea Center. We're Pitt's hub for innovation entrepreneurship. We do programs like this, and we have lots of resources for you to help you get your idea and your startup up off the ground, like EIR appointments. So if you're interested in anything like that, you can reach out to me, or you can talk to Rhonda. Rhonda's our building director, and she'll be joining us shortly, a little bit into this session here. So I'm here just to make sure the trains run on time. I say that every time. I'm going to say it again. So it's wonderful to see you all.
So before we start the session, one of our traditions, when I remember to do it, or Dave reminds me to do it, is that we have we call this, it's part of the Connect series, and it is an opportunity for anybody on the call to reach out to anybody else who's on the call and ask, are you looking for a teammate? Are you looking to join a team? Do you have any announcements? Do you need any help with anything? So this is an opportunity to tap into, the ecosystem here. And, we've had actually some great success. I've had founders find each other. Others are looking for people to interview for customer discovery, gotten introductions or whatever. So I'll just pause for a minute and just say your name, say what you're looking for, and then at the end, say your name again, because nobody really listens until they know, like, oh, this is something I should pay attention to.
Well, I'll go ahead and kick it off, Kit. My name is Tyler. I'm one of the founders of a prototype here at CMU called GovScan, which is a AI-powered large language model that searches large government PDFs simultaneously to retrieve information back. We're using a retrieval augmented generation as a method of that retrieval. And really, I just want to ask if anybody would be interested in talking more about has any experience in working with large government documents and retrieving information, really unlocking information from these documents. It's often left kind of stored and saved in a file. And would love to have you reach out. I'll post my email in the chat here. And my name is Tyler. So there we go. Booked it with my name.
Nice to know.
In particular, as anybody, that works in government has worked in there, so like when they do these requests for comments, when they're proposing a regulatory change, is a great example of, but it could be, there are other types of documentation, foreign contracts, I don't know. So Tyler, thank you for being the first to jump in there. By the way, we just got some feedback from the last session from some of the participants. And I thought it would all be really great if everybody turned on their cameras. And I don't know what everybody's in different state of repair or disrepair or dress or undress, but if you turn it on, it actually makes for a more interactive session. So, okay, I saw Matt, your face just showed up. Do you have a request?
Nice. So everyone, my name is Matt Oriente. I'm a current master's student at Chatham University. It's just stone's throw away from Pitt. And I'm a co-founder of a spin-out from my undergraduate, which was at the University of New Hampshire, called Hydrophos Solutions. And we extract phosphorus from wastewater before it contaminates our waterways in a usable form to be used as an input in fertilizer. So basically closed loop system. And I guess because we're considering a big chunk of our customer makeup being municipalities, municipal wastewater systems, kind of on a similar theme to Tyler in terms of working with governments and kind of possibly some requests for proposal projects. Kind of curious, just in a legal sense, what some of those processes are and working with municipalities. Just some things that we should keep in mind if that's going to be a good proportion of our customer base. And again, my name is Matt Oriente, and I'm with Hydrofos Solutions.
So Matt, I will just tell you this, having worked with another team way back that was looking at, they had a chemical that would, or something, a process that would pull out phosphorus. And what I learned is the primary, and you probably know this, so forgive me if I'm repeating it, but the primary source of phosphorus getting into water comes from fertilizer. So the municipalities that were most interested or had the biggest problem were not going to be Alcosan here in Pittsburgh. It's going to be like in Westmoreland County. It was going to be wherever they have farms with fertilizer. So although Alcosan would be the obvious, and I think they're used to being approached by our various university startups just to do informational interviews, they may not be your most prominent person, that you want to deal with, but they probably do know their counterparts and can make some introductions.
Yeah.
Okay, so, and I don't know anybody at Alcosan. I don't know if any of the lawyers do or not. Emin, you've got your camera on. You gonna make a pitch?
No, just following your advice to turn on my camera, show my face.
Well, thank you. It's nice when people actually do what I ask. It doesn't always happen. Okay, anybody else got a shout out they want to make? All right, David, we're
All right.
turning it over to you.
Okay, well, let me thank you and welcome everybody. This is one of my favorite presentations because it's the worst mistakes. So we get to sort of look back and think of all the mistakes that startups have made and go through them. I'm sure we're going to hit all of them. We'll hit some of them. Let me introduce myself. I'm a partner with K&L Gates, and I've been there more years than I care to admit. And I have the pleasure of working with lots of growth, called startup companies, growth companies, whatever it is, and take them from beginning to end, whatever that may be, whether sell, license, or whatever. And as a group of people in my firm enjoy doing this, so it's a pleasure to be here and work with you and be with you. I have some colleagues with me, some partners, some people from other firms who have volunteered to join me today. So let me introduce them as well and let them tell you a little bit about them as well. FJ?
Sure, thanks, David. So my name's FJ Lucchino. I'm a lawyer who works almost exclusively with technology startups, technology companies of all kinds, life sciences, software, chemicals, all different kinds. I've been doing this kind of work since about the year 2000 and really enjoy it, really like working with founders, working with people who are very passionate about what they're doing. And so anyway, there's a lot of energy there, and I enjoy working with those kinds of folks. So that's, and by the way, I'm a solo practitioner. So unlike David and David, who work at large firms, I work at a very small firm.
David.
So you're right, FJ, you're a sole practitioner. And I am with Dentons, Cohn and Grigsby, which is literally the world's largest law firm with 8,000 lawyers in 88 countries. But for the vast majority of my career, I was with Cohn and Grigsby, a regional firm, and we combined with Dentons about 4 years ago. But I've spent almost my entire career working in the technology ecosystem in Pittsburgh. In that respect, David and FJ and I are kind of three peas in a pod, whether we're working for, large firms, small firms. We all have loved working with technology firms. And one of the joys of practicing in Pittsburgh all these years has been able to work with some of the most interesting, smart, and leading experts in the world coming out of CMU, particularly, and software and robotics and AI, and in Pitt, generally, but not exclusively in life sciences. So I think like FJ and David, my practice has been, split among whatever is the leading technology in Pittsburgh at the time. And it's changed over the years. But the one thing it has in common is terrific technology and the ability to take world leadership in what they do. And we're happy to be part of it. And I'm happy to be part of this particular program, which I've now done for many years. Because it's always interesting, because every year that we do it, we think of different mistakes. And they're very often the ones that we've just seen. Because they never stop coming. The mistakes never stop coming.
Yeah. Let's see. I guess that's our group for today. I know Stephanie and Kit are going to weigh in heavily with mistakes they've seen through their working with companies. So let's we'll go through a different bunch of areas, but let's clump it a little bit. So let's start at the very beginning when folks come in and maybe to FJ and David, and they just come into your office and they say, well, we've got a business, we've got an idea, and there's a group of us that are thinking about doing this together, right? And do you, maybe one question for you is, have you seen, maybe think about the team and just selecting the team, and what mistakes have you seen people make selecting their co-partners, their co-inventors or their partners? David, let me start with you, because I know that's one that you have a interest in.
I mean, I'm happy to jump in on this, David. Sometimes it's not just who they've selected, it's who they haven't selected. Very often when the teams come in, it's all technology people. And I don't know with this group here, some of whom I can see and some I can't, how many are sort of technologists at heart and how many are business people. But I know that most of the companies that we see are all brilliant technologists. Many of them are professors at CMU, at Pitt. They don't plan on leaving the university to join the company. Some are graduate students. They are planning to leave the university to join the company. But again, they have all the technology experience, which is critical, but they haven't brought in the business people that can turn the technology into a commercializable product. And I am really seeing companies suffer for lack of that business leadership. First, just the recognition that you have to have it. And that's sometimes not an easy sell. But then secondly, getting it. So I think those are the problems that I try to identify. And, it's not that I would look at any one person and say, you're not competent to be CEO, but I'll often frame it the way it really is, which is, what are investors going to think when they see this team? Are they going to invest in a team that's comprised of a professor or two professors and maybe one technologist and no business leadership? So to go beyond just the technology or maybe even an MVP, how do you get to the marketplace?
And there needs to be, in my experience, an acknowledgement. I mean, in the initial stages, it's often the inventors that will play that role up front. But it seems like there needs to be an acknowledgement that they will get that kind of help and that kind of assistance and expertise when it's needed, right?
Yes.
I remember one founder who once said to me, I said to him bluntly, will you be willing to step aside to bring in a CEO? And he said, absolutely. Just as soon as we find one who's would be better at it than I am. And I knew exactly what he meant, which is it'll never happen.
Right. And just another point is that one of the things that we run up against, because we're not just lawyers, folks. I mean, we are lawyers, but I hope we're also considered to be trusted advisors. and people with a good business sense of what can make you successful. And one of the things that we run up against is the companies that have come out of CMU that have never brought on the business people, that have been 100% owned by the professor who dreamed it up and was able to sell the company for millions of dollars. And a lot of people come in and say, well, that's what I want. That's what I want to do. And it's like, well, maybe you can do that, but likely you can't. So we need to start thinking early on, realistically about how you're going to get to your goal.
So I totally agree. Among the founders, I don't know if you've run this, but I've gotten more concerned over time with the relationship between the founders, and making sure that they're a pretty good fit. Have you seen that? I mean, along the way, or?
Well, yeah, I mean, what I've seen is a lot of times when the companies or potential companies come to me, they've actually usually been working on it for a while. And they have developed some kind of working relationship with the other founders, or maybe in some cases not a great working relationship with the other founders. I have seen mistakes made when somebody starts a company and they basically go to the people who are maybe nearest to them in some way. Maybe you have one person who's the lead technologist, but you have some others who are sort of maybe not fair in all cases, but along for the ride in some ways. They are nearby, they are friends with the founder, they have worked with them in some way, but maybe they're not the best fit for that company. And what ends up happening over time is that they eventually find that out, and they find it out maybe later than they should. And it's really best to find those things out sooner rather than later, because it gets harder. And I've had a number of cases where the main founder, I'll be representing a company, and the main founder will say to me, oh, I want to buy these people out. I want to get these people out of the company. What can I do? How can I do that? And it's depending on how you set up the arrangement, the founding arrangements, that can be, that can be difficult or maybe less difficult. But, we will talk about vesting arrangements and how that works. I won't get into the details of that. But I mean, I think that's just one of the things I see with founder groups.
I'm literally having a meeting tomorrow at 4 p.m. with the founder of a company that I love. They have great technology and great prospects. And she came to me last week and said, I now realize I don't have the right team, because she didn't know what she didn't know.
Yeah.
She thought it was the right team, but getting more deeply into it and then understanding the market that she was getting into, that the team that she had surrounded herself with didn't know anything about that market, didn't know how to penetrate the market, didn't know how to sell into the market, didn't know all the landmines that lie ahead. And that's hard, because she has worked with these folks, but they reach the limits, their capacity, very quickly.
So what are you going to advise her, David?
I'm going to advise that, fortunately, all these other people, Kit, have a very small percentage of the company, and some have none. I'm going to tell her that we need to make a concerted effort, along with some other advisors that she either has or I'm helping to bring to her, to find the right people, and bring them in sooner rather than later. We know the skill sets we need now. Now we know that.
Yeah.
And sometimes it could be hard because you're telling someone, you have a founder who needs to tell somebody who may be a good friend with personal friend and say, maybe you need to leave the company, or maybe, or really have a diminished role in the company. And the person who's hearing that may think, wait a second, no, I have had a very important role in the company. Why are you doing this to me? And it can get very personal in some situations, particularly if the people didn't just come together at the time of this, but had known each other beforehand. So it can be tough.
And this is where
I
it's
can give you
important.
an example of
I'm
that.
sorry, go ahead, Kit.
It was a team of two. Kiro was at CMU, but his best friend from high school was at another university. So at the time before Zoom, we were doing a lot of this by conference call, and they were spending more time on actually the product, as it were. And I kept on saying, we need to talk about the business side of this and look at sort of more who should get what. But they were starting out on this 50-50 type of thing. And then over a course of time, it became readily apparent that the one I was particularly working with at CMU, he was doing 80% of the work, where John was doing sort of what do we call marketing, but we never really could see much visibility. So when Kiro tried to have that conversation a little too late about what the actual roles should be, what the worth should be in terms of equity, John went ballistic. And he went back to his father. His father hired a lawyer, which meant that Kiro had to hire a lawyer. So they lawyered up, they got depositions, and I was asked if I could come up to Trenton to testify. So I flew up, so I was there kind of waiting, but it killed the business. Kira had to take a different job that paid a lot more so he could pay the lawyer. Not that I'm objecting to the lawyer pay, but it was more the fact that whereas it was coasting along, and the problem is that they were right on the cusp of doing these really good pilots. The product was ready to launch, and he never recovered. So it's have the conversations early on, and sometimes just because they're your best friend doesn't mean they understand.
Yeah.
I mean, you all just said it, but I lived through that example, and I keep in my office the copy of the depositions.
Oh, geez.
So I show them. It said, "This is what can happen if you don't get it right."
So let me make
That
one
gets
other
the
comment.
structure. Go ahead, David.
There's one more sort of related point that goes to both employees, co-founders in this situation, which is one client of mine once went to a roundtable of CEOs, and they asked them what the one mistake they made was. And every one of them said the same thing. It was amazing. They didn't fire somebody fast enough. The first time it occurred to them, they needed to do it. And the problem only gets worse. So if there's a problem with a co-founder and you're not going to do it, you need to address it right away. If there's an employee that's not going to work, you need to address it right away, because it's only going to get worse.
I'd have two follow-ups to that. One is, I mean, this gets to structure, right?
Yeah.
It's if you have two people, it's not automatically 50-50. If you have three people, it's not automatically a third, and a third. You really need to think about, who is the founder? And frankly, that founder should have control. I mean, the principal driver behind the company needs to maintain that control in the early stages so they can make those hard decisions. If they're successful, eventually they're going to give up that kind of complete control, because as investors come in, their percentage of ownership is going to drop below 50%. Preferred stock investors will negotiate for various rights. So their control is going to be chipped away. But you really want to have it at the beginning. And the other thing is, frankly, you can see sometimes where people are not agreeing at all, even in these very early stages and meetings. And everyone on this panel can assure you it's never going to get better.
So, FJ, why don't you one tool to address this is vesting. So take 2 seconds, and because one of the mistakes people is they don't vest stock, and so maybe we should give people just a quick primer on that.
Sure. So when you start a company and you're going to have ownership of the company, the founders are going to have the initial ownership of the company, whether it's 1 or 2 or 6 or however many founders you have at startup and at formation. And so you have to split the equity among the founders, and it actually has to add up to 100%. There's no other way to do it. So you have to figure out how much each person gets as a percentage at founding. And as David said, one founder should generally have control in most cases. And but what you do, the thing is, when you give equity, if you don't do anything about it and you just say, okay, you're going to own 10%, you're going to own 20%, I'm going to own 40%, whatever, and you add up to 100. If you don't do anything otherwise, then they will just own it. It will be theirs, and you won't be able to take it away from them in most cases, not easily. But what happens is that people don't always stay with the company. If you have more than one founder, there's a chance that one of those founders, and there's a good chance, and if you have 3 or 4 founders, there's a likelihood, I would say, that at least one of them will leave within a year, because they'll have personal reasons why they want to leave, or they'll get an offer their dream job, or they'll just lose interest, or they won't be getting along, or somebody will want them to leave. So what you don't want them doing is leaving but still owning a chunk of the company, particularly if they own, more than a very small percentage. Certainly if they're in double digits, you don't want them walking away with that if they haven't been there very long. So to deal with that, you have a concept called vesting, whereby they're issued the equity. Typically, they're issued the equity at the founding, whether it's stock or whether it's an ownership in an LLC or whatever, and they have to vest it typically over time. And the most common way to do this is what they call cliff vesting, which is typically what they call a 1-year cliff, which means that for the first year, you don't own any of it. Or you own it, excuse me, I misspoke. You do own it, but if you leave within a year, the company can reacquire it. Typically what you paid for it, if you bought the stock. So what that means is if somebody leaves and they're not within the first year, you can usually, for a nominal amount of money, the company can buy the stock back, and then that person doesn't have any. Now, after a year, they might vest in a certain percentage, and the most common way I've seen this done, and I've seen it done a million different ways, but the most common way I've seen it done, I'd be curious what David and others think, is 1 year, no vesting for 1 year, and then for over the next 3 years after that, so for a total of 4 years, monthly vesting. For the next 36 months after the first 12. But I've seen all kinds of ways. I've seen milestone vesting. I've seen personal milestone vesting. I've seen company milestone vesting. I've even had one client that wanted to do daily vesting, which I thought was a terrible idea, and which they eventually decided was a terrible idea after some period of time. So anyway, but it's a way to make sure that if somebody hasn't been there very long, or it doesn't say the full amount, they don't get to keep all that equity, because as the others can attest, when you have investors come in, they hate the idea of debt equity, that this equity is going to ownership, is going to somebody who's no longer contributing to the company. So anyway, I'll stop my little order there.
Okay, sometimes I even go further, and so going back structurally, the idea is to make sure you minimize the equity that's allocated to people who are no longer contributing to the company. Vesting the stock is a means by which to do it, and the beautiful description of it. Sometimes I go even further and say, even vested stock, I have a right to buy back at the then fair market value, on the theory that the founder should get the benefit of the value from the time they came in to the time they left, but they don't get the value after that. And I need to take that equity back, because I got to give that to other people who are going to keep driving the value. And sometimes it's a percentage. Maybe you get 50% of the equity that they vested, or some fraction of it. And I have seen people not do that, and they vested too quickly. And again, I love the phrase debt equity, too much debt equity. So what it's worth.
I've got a related story to that too, and you all know him. His first name is Rick, but he was one of his founders was not contributing, and this is what I attribute to the fact that, one, he did talk to his lawyer about the partner did agree to leave, and instead of talking to his lawyer about this, what do I need to do? And secondly, even reading his own bylaws, the partner left, and then it came time when he was going to get some investment, and he realized in his bylaws or operating agreement, whatever it was, that he had 30 days in order to make that offer of buying back the equity, and he missed that deadline. And the partner just said he was a little pissed about being, excuse me, we're recorded, angry about being kicked out. He said, well, it's going to cost you $50,000, whereas before it would have been $5,000 because at the time the worth of the company in there. And it was one of those, he was truly over the wall. So read your documents, and sometimes when you make changes like that, also consult with your lawyer so you understand if there are timelines or implications. And so Rick ended up having to write a check for $50,000, of which he didn't really, I mean, he could have used that money in the business.
I think we've all seen the perils of dead equity. Um, as FJ indicated, when investors come in, if they see that 30% of the company is owned by people who aren't there, that's a really hard sell.
It is.
Now you're talking about maybe creating a new company, basically, to buy the assets and get a fresh start, which can be done, but it's complicated. I have been in situations, and it's also important to, when you think about this vesting, cliff vesting, and then monthly or quarterly, what that represents is that first year is kind of a show me year, show me you belong here. And if someone makes it past that first year, then it's like, okay, now we want to hang on to you. And that's why we are accelerating this vesting now, not to just the next year, waiting another 12 months. But if we vest you in the next month or the next quarter, we're hoping that you will be enticed to stay with the company and continue to vest rather than taking another offer that's out there. But I will say that I've seen issues where we had those kind of repurchase rights, David. There have been too much, the vesting had been accelerated too much early on. And unfortunately, the circumstances surrounding the company's early financing put a value on the company that was just higher than it should have been.
Right.
And the way the language was drafted, it was full fair market value. There were no discounts for minority interest or lack of transferability. And the company ended up buying back the person's shares, but really paying a lot for it. Now they kind of ameliorated the impact of that by paying with a note.
Right.
But every year that a big payment comes due on that note. And at the end of the day, was it really worth it? We'll never know the answer to that, but it's created more heartache than it should have.
Yeah. So on the vesting, this morning I woke up to an email from a client that said, forwarding the email from June of 2023 that said, by the way, I didn't file that 83. I'm not, you think I'm making this up. Was I supposed to file that 83B election? Because I didn't do it. This morning I got this email from 2023. So, which is pretty funny. Well, not really funny, but the point is that I have seen people, when you get restricted stock, and I'm not going to go all the details now, but the point is you want to file an 83B election within 30 days after you receive it. It's required that you file it within 30 days after you receive the stock for tax purposes. Not doing it has adverse tax consequences, which I can go through another time. But the point is, that is when you get restricted stock or stock that vests over time, it's essential that you file that 83B. It's a tax form with the IRS within 30 days after you get it. And this person did not. And so that's a problem.
We
David,
just sent out, go ahead, Stephanie.
I was just going to say, we have a question from Matt.
Yeah, thank you, Stephanie. So I just had a quick question. So in terms of I guess, my startup, we're also on a vesting schedule. And this hasn't happened yet, but say, someone starts really slack and they're not doing their work and we find that they're actually a big liability to the team, they might have to leave. Now, in terms of, say, buying back, either their stock or their stake in the company, I'm curious if you've ever run into issues with valuations in the company because it's so early stage, pre-revenue. Are there any, maybe discrepancies that arise in that, the founders, the original founders, might think the company is valued less than what the person who's getting booted out is, and just maybe like possibilities in regards to there, because that also might cover up a big dispute as well too, just what the company's valued at that early stage.
So when I've dealt with that, so make a distinction here between repurchasing stock that has not yet fully vested, that is not vested. So that portion that's not vested, typically the way I would set that up is that the company only has to pay what the founder paid for that stock. And usually when you're issuing stock at founding, you take the position that that company might be worth a few $100. I mean, or it could be a few $1,000 depending on how much money, or it could be more depending on how, but you take the position that the company's worth very low. And so the total amount that the founders collectively put in could be a few $100, could be a few $1,000, could be $5,000 or $10,000. It could be much more. But basically, it's a relatively low amount of money. And so if that one founder put in, let's say they put in $500 to acquire their stock, and they were not vested at all the company, in the way I would typically see it set up, is that you only had to pay the $500 to get it back. So there wasn't even a question of valuation. They had agreed in advance that if it's not vested, the company can reacquire at the price that they paid for it. So they're just getting their money back, basically. Whereas now, if, as David discussed, you have a provision where you can buy it back, even if it's vested, then typically what I see in that is it is some kind of, some kind of fair market value, but typically you'd also want to be able to, and as the other David was alluding to, put in discounts for lack of marketability, meaning it's not a publicly traded company, it's not easy to sell, lack of control, you're usually buying back less than a controlling interest. Those are standard deductions that you can take from off of the fair market value. But yes, if you are in that situation, you're trying to buy it back at a fair market value or something akin to that, then yeah, you can look to different things. If you've ever had an equity round, a priced round, that will be one indicator of value. You can have a valuation done by a valuation firm. I've also seen the companies just say, look, this is what I'm going to offer you. And then you get into a negotiation with them and see how far it goes. And sometimes the founder may want to negotiate with you and hire a lawyer and do all that, but sometimes they'll not. I mean, so it depends.
Matt, I think I'm going to tell you what, if you came to me, probably not as company counsel, but let's say you were the individual, because if you were company counsel, we would have drafted the documents. I would say, what do the documents say? Because the I don't know if you're asking about this because you're thinking of forming a company and you're wondering what to put in the documents, or whether you actually have the company. But if it's already formed, this will be in there. It should be in there, that explains whether someone has the right to buy back vested shares. And if they do, how do you determine fair market value? And at some point, maybe it's a board decision, or maybe you bring in a third party to value it. But in the absence of that, if no one's under an obligation to sell you their vested shares, and you're not under an obligation to buy it, then it's a negotiation. And what's interesting is that departing founders often feel like, if I'm not at the company, it ain't worth very much. Because I think I'm the straw that stirs the drink. And chances are you can get it at a lower value because they think anything that I get is better than the nothing that I'll get with me gone from the company. So, those discussions are definitely had.
Yeah.
Can I make a related mistake that I see that is very common? It's a little more subtle, for lack of a better term, which is that we've talked a lot about what do the documents say, and here are these documents. And there is, it is true that these, there are form documents that lawyers use, and so they're not creating a new form just for you. They've done this before, and in fact, it's a good thing they have a form, because they will spend time over their career perfecting or trying to perfect their form and improving it, and putting in a lot of provisions that are going to be helpful to you. But one of the mistakes that I see is that at the formation, or when you're putting these in place, and I mean, I think that the lawyers may bear some burden for this too, but I mean, do bear some burden of like making sure the client, the founder, understands what's in the documents. Because when it gets to the point that the documents are being put in place, I generally find, not always, but generally find that the founders are really in a rush because they have some deadline. They're trying to apply for a grant, like an SBIR grant, and they need to get that in place right away to get their grant deadlines coming up, or they're maybe they're trying to get investment, or there's some other reason why they have maybe been working on it without forming a company. Now they want to form it, and they're really in a rush to form it. And it takes time to sit down with founders, whether it's in person, on a Zoom call, whatever, and walk through the documents to a point that they really understand in a meaningful way what's there, because it's not easy to understand it. I mean, the lawyers have looked at this again and for years, and so they understand it, but for most of the founders, this is the first time. So so it's just, it's a tough mistake to correct, I would say, because it really requires you to take some time and really do this not at the last minute. But I understand that that's the way the world works, and it happens a lot to all of us, that things get done at the last minute. So I would just say give some thought to try to give yourself as much lead time so you can understand all of what's being given to you and put in your documents, because it may be important, it may be very important. But
David, can I hop in with something? FJ just said something that I want to bring to people's attention. Because very, very rarely do people focus on this. I think all of us panelists are used to forming companies, particularly out of CMU, that have substantial foreign national ownership. So for purposes of this, we're assuming that we have founders who are on an F1 visa. They have the proper visa status, or they have the proper work permit status, because they're either on curricular practical training or optional practical training. They're able to work in the US. They're able to own shares. They're able to work for the company. And now they need to go for an SBIR. Well, there's an issue. And the issue is you can't have more than 50% foreign ownership in a company that's applying for an SBIR. So if you know when you're forming your company that initial funding is going to be coming through an SBIR, and that's great funding, right? That is non-dilutive funding coming from the government to develop your product. It's a wonderful device, but you're not eligible if you have that more than 50% foreign ownership. And so I try to find out from my clients early on, where are you getting that early money from? And if that's going to be the case, we need to do the early structuring of the company in a way that's going to enable you to get that funding. So,
And there are workarounds, but you got to address it.
yes.
Right. Yeah.
So I just will make a point that hopefully is coming across in spades, that one of the big mistakes I see is when you don't get somebody who specializes in startups, that it's, do you get the orthopedic surgeon to do your brain surgery? You know, it is a specialty in there too. And when everybody, it starts out because you're going to file your articles of incorporation and you have a relative or a friend, oh, I can do that. So I'll do it. It won't cost you anything, because you think, and that's the beginning of what I call the slippery slope. Because filing the articles is what, 2 pages, $125. But then what you need is what goes along with it, the operating agreement, the bylaws, whatever that the David and the FJ are all talking about, that have the meat of how the company's going to be run. And that's where, or, you know, what happens with 83Bs that these lawyers don't know.
So let me take FJ's point, maybe broaden it just a smidgen, which is that when he talked about going through the formation documents and making sure you understand it and take the time out, let me broaden that to just contracts generally. So for example, NDAs. It's really important that you understand what's the non-disclosure agreements you're signing. Your terms and conditions, other contracts, commercial contracts. I have seen clients sign pieces of paper they don't understand. And that is a huge mistake, leading to very unhappy consequences. And so it's painful. It's not a lot of fun to read contracts. But even I don't like it sometimes. But the point is, you got to understand it. It's binding, and it has implications. And it's essential that you understand the pieces of paper that you're signing. And getting a lawyer to explain it to you and go through it with you with care is really important.
It's not uncommon, David, to that point, that with NDAs, that it's a client will, before I ever work with them, they will have signed NDAs, and they will think that the NDA contains intellectual property provisions, which generally they do not. There are independent contractor or consulting agreements or whatever, which typically do contain intellectual property provisions. But if you just get somebody as a founder to do some work for you, and you haven't signed an NDA so that, well, they can't talk about it, you now have you have potentially have a big problem if they're writing code for you or something like that, that there was nothing, and they're not an employee yet, you haven't hired them, but they're just, you're working with them under an NDA. There's no intellectual property assignment, so they may still, they probably do still own that intellectual property they've created for your company. The company doesn't own it if you only have an NDA, and it's just a typical NDA that just protects for confidentiality and does not get into intellectual property. And so that's the kind of common mistake I see, a misunderstanding about what that piece of paper is meant to do.
Yeah, totally agree. Let's switch gears a little. Unless somebody, Leslie, you got a question? Maybe
I don't.
okay, cool. All right. So let's switch gears a little bit and maybe talk about raising capital. Because we got you know, we've got our founders together, and so now we want to seek some financing, and David already pointed out some issues regarding SBIR and obtaining non-dilutive financing, which is wonderful. But now we're going to raise money from third parties. And so let me, maybe David, from your perspective, maybe think a little bit about whether they should go for a priced round or a non-priced round, and whether they make mistakes doing that, right? In the first instance,
Sure.
Is that a good place to start?
Yes, that's great. I mean, I tell people there's a funding continuum for early stage companies. We see it all the time in Pittsburgh. In the Valley, if you're an experienced serial entrepreneur, and you pick up the phone and call your venture capital friends and say, I'm going to start a new company, they may say, okay, where do I send the money? And by the way, what are you going to be doing anyway? Unfortunately, it doesn't work that way for first-time early stage founders. So your first money in is very likely not going to be a priced round, because we have no idea what your company's worth. You don't know, your investors don't know. Time will tell. But you do need to get that early funding in. And the typical method of getting it is through an unpriced instrument like convertible debt or a SAFE, a simple agreement for future equity, where people are in effect making a deferred equity investment. The intention is to see this turn into equity at some point, and generally at a discount or at a capped value, even if the company becomes extremely valuable. That's their reward for taking the early risk. And then as the company progresses and begins to show its value, it's better able to negotiate with professional investors, whether they're strategic or financial or otherwise, a better value that will then convert the convertible debt or the SAFE into equity. And then you have your clean cap table. That is a typical, and most of the early stage funding agencies in Pittsburgh are either convertible debt, and some of them will do now SAFEs. So I just want to say a couple words on this. Convertible debt is better for the investors because it accrues interest and it has a maturity date. So the investors can put pressure on the company to do something if they haven't raised equity funding by then. SAFEs are similar to convertible debt, but they don't have a maturity date and they don't accrue interest. They basically sit there waiting for an investment to come. And if that investment never comes and the company's sold, they still have a chance to get, a very nice return if they're capped. So we're seeing a lot of issues with convertible debt because it's been hard to raise money these last few years. And a lot of my companies have notes that have been out there past the maturity date. And some of them have run into colossal issues with investors who in the olden days would never have made unreasonable demands on the company. They would have just accepted it and recognized it and worked with them. They're not so accepting right now. So I think given my druthers, if I'm representing the company, I'd like to use a SAFE rather than a convertible note. But that's kind of, standard early stage funding. And I guess the last thing I would add is you can become addicted to this early stage funding. You can raise millions of dollars in convertible debt or safes. And the more you raise, the harder it is to raise a priced round, because the early stage financing, those instruments are going to convert, and they may end up as the majority of the ownership in the priced round. So I think the caution is, you'd like to use a SAFE if you can, but if you can't, no big deal, just deal with it. And you don't want to keep raising SAFE or convertible debt money forever. At some point, you want to put your foot in the ground and do a priced round and get your cap table in good shape.
That's well said. As an analog to the read your document lecture that I gave, a similar lecture is making sure you understand the cap table and the implications of the convertible debt or the SAFE. And I it is amazing to me how many clients, well, not clients, because I force it to them, but others and founders don't understand this. And they really need to do Excel spreadsheets or whatever it is to really make sure that they understand the implications of the SAFE and the convertible debt and what that means for their cap table in the future. Also, David mentioned caps. And often in the convertible debt, in the old days they weren't there, but now investors almost always require some kind of cap. So there's a maximum amount under which the SAFE or the or convertible will convert into equity. Well, that has implications for the founders. That has clear implications on how much equity the investors get when there's a conversion. It is essential that you go through some what ifs at the time that you raise the capital, so you understand exactly what you're giving up. And so if I raise, X million dollars at this valuation, how much have I given up? Is it pre or is it calculated pre or post the notes? The way it's done, and just I joke about that you can't. Founders cannot leave that calculation to the lawyers. They need to understand it, and the lawyers who do this kind of work need to understand the math behind it and be able to explain it. It just has to be the case. So I really encourage that because people don't always understand. And the last thing you want to be surprised when there's a round and you're surprised by how much the company gave away. So that's essential. And understand the concept of the cap, because that's very much a part of the negotiation at that point.
Can I make one minor point, but about still on raising capital and stock? It's really a question of stock, and it just because I see it all the time, and it's just a misconception that a lot of founders have. They don't understand the distinction between what are authorized shares, what are issued outstanding shares, and what fully diluted shares. They each have and basically when you form a company and you have to, if you form a corporation, you have to state what the total number of authorized shares you're going to have, meaning the total number of shares that the corporation has the authority to issue. So let's just say you make it 10 million. I'm just making up a number. You can, the company can amend that and change that at some point. But that's with the approval of the stockholders and the board, you can change that. But unless you go to that process of changing it, you have, let's say you have 10 million authorized shares. The founders seem to think that authorized shares, that's like we have to use them all up. They don't understand that that's not just you would never issue, I don't think, very rarely would you ever issue all your authorized shares at the beginning. You would have some issued and outstanding shares. So when somebody owns like, say 1 million shares, they might own 100% of the company, even though there are 9 million authorized shares that are out there. If they own all 1 million shares, they own 100% of the company. They'll think, I own 10% of the company, but they don't own 10% of the company. They own 100% of the company. So, and then I try to explain this to my clients when this comes up. I'm just saying, to understand, as David said, David said, you have to understand your cap table. Well, to understand your cap table, you also have to understand what the various, terms are, what they mean, and so what it means when you have issued and outstanding shares, or fully diluted. I mean, which basically means how many shares would be issued if all your convertible debt, for instance, converted into equity, and all the options you had that you had issued became stock. And then there's authorized, which is the total number. So I'll stop there, but it's just a common misconception that I see among founders, and something to be aware of.
Dave, I'd like to offer a high-level observation, because it's not always immediately clear to people, and it kind of swings back to what we were saying at the very beginning about the CMU professor who wants to own 100% of it and sell it for $15 million. There is structural dilution and there is economic dilution. You're never going to own more of the company than you own on the day that you form it. But as you grant options to employees and people who come on board, key team members, as you raise money from investors, the percentage of the company that you own is going to get less and less. That is structural dilution. The whole issue here, the name of the game, is the economics. What's the value of what you hold? Would you rather have 80% of something that's worth $100,000, or would you like to have 30% of something that's worth $30 million? I mean, yes, you are going to go down in the percentage, but as long as that value of your stake is growing, you're doing a terrific job. And that's what you're shooting for. Whether you sell early or take more investment and take more dilution and sell the company early, or you take additional investment, take more dilution because you think you can grow it to 5x the value. It's a wonderful problem to have for a company that's successful, but don't lose sight of that.
Let me go to any other mistakes you've seen people make in raising capital? Otherwise, I'll go to a different subject. Oh, billions of them.
Well, I guess one of the questions is who are your investors?
Yeah.
In a perfect world, you'd like to have smart money. You'd like to have people who are experienced investors who not only are going to bring capital to the table, but also a wealth of experience. And now you're sitting on the same side of the table. Once you've had that negotiation over the price they're going to pay for it and what the instrument's going to look like, now you're on the same side of the table and you're trying to grow the value of the company. And if they really have wonderful contacts in the industry, if they're experienced investors who can come onto the board and help you avoid a lot of the obstacles that you don't even know are looming ahead of you, that's great capital to get. And sometimes you get dumb money. And I don't mean to besmirch the reputation of the people who are investing. It's just that they don't have any experience in your industry. Why are they investing in you? They believe in you. They like you. And listen, capital's capital, and the last few years have been really tough. So any capital is probably pretty good capital. And then you can have investors who don't have your best interest in heart necessarily. They have their interest in heart. And strategic investors can be wonderful because they may not drive as hard a bargain on the valuation of the company, but they're as interested in what the company's product is going to do for them as they are in the investment. and maybe you're not quite on the same page with what they expect to get out of the transaction and what you expect to get out. And bringing in a strategic investor can impinge on your ability to sell that company down the road to, say, a competitor of theirs. Again, it's very few of us have the ability to sit back and choose and say, I'll take that investor and that and that. You know, you sort of take what you can get, but those are the kind of issues I see over and over again.
Can I follow up on one thing David said about strategic investors is what I've seen. I mean, and yeah, they're taking on a strategic investor can be a very good thing for a company, but you also need to be careful about what the motivation that potential strategic investors, because I've had clients who, and you hear from like a big company, a well-known household name company who, or certainly at least in your industry, if not nationally, who was interested in you, and you're flattered by that, and you think, well, this is great, but maybe all they're really doing is just trying to find out who's doing what, and they want to get as much information about you as they possibly can, find out, do you know anything they don't know? Do you have technology they don't have? Can they steal your technology? Because I've seen that too. I mean, so when you start talking to those strategics, be very careful, have a very well-crafted NDA, but also just as important and probably more important is just be very careful about what you disclose and when, because even with the best NDA, if a large company comes along and starts, taking your technology, and you're a small startup, you can't compete. I mean, you don't have the resources to, in most cases, to do anything about it, practically speaking. So just be very careful about that.
And whether it be the strategics, even the angels and the VCs, one of the things to be careful of is what rights you're giving them. Giving those folks, and they like to say that they have influence, but they're looking for veto rights or approval rights. And with the strategics, they want approval rights often in the company when the company is being sold and to whom it's being sold. Because again, they don't want to go into a competitor of theirs, and so they want rights. VC sometimes will want the right to approve a sale of a transaction, a sale of the company, additional equity, etc. And so you need to be careful. And I have seen, I told a story about the one client who did not realize that they had given, we represent them again, a approval right to the first investor over a sale of the company. They had several more rounds of investing. And when they went to go to sell the company, the first investor who said, no, we don't think this is the right time to sell. And everybody else wanted to sell. And they said, we have a veto right. And they all went scurrying through the piece of paper, and yes, there it was. And nobody had noticed it. And they had a veto right. And I said, we're not approving it. And they did sell the company, but that company, the first investor who had the veto right, guess what? They got more than they otherwise would have gotten into the capture. They basically bought that right out from under, bought that right from them.
David, I think it's important for people to understand, well, why wouldn't they want to sell? Well, there's a big difference because the founders have paid like a 100th of a cent a share for their common stock that they got. And the investors have come in and say invested at a $15 or a $20 million value. And they're targeting a return of, if they're like most VCs, they're targeting a return of 10x on their investment that they consider 4x to be a terrific return. But they don't want to sell it at 2x. They didn't take this risk to double their money. Right. Now, for the founders, selling it at double the valuation that the investors came in could be a fantastic result. It could be life-changing money, but it's not what the investors had intended. And so we often end up negotiating some threshold that, hey, if we can get you back 3x or 4x your money, you can't veto the sale.
Yep. All right. Let's spend a moment on, I know we don't have that much more time, maybe intellectual property. FJ, you already touched on a little earlier the NDA and the fact that it turns out that that's not an invention assignment. and how important it is to get invention assignments from folks. And let me emphasize that I have seen clients go to be sold, and they don't have the appropriate invention assignments from employees and independent contractors, and we have to scurry around to get them, and it's a huge issue. And so being able to show that the company owns the intellectual property that's using with respect to these technology companies is huge. What about the potential of infringing on somebody else's intellectual property? So that's or that kind of thing. David, have you seen anybody maybe have issues there?
You mean having when the company's getting started?
Yeah. Yeah.
Well, if they're going to file a patent, they're going to look. The patent lawyer is going to look for prior art.
Yeah.
They're going to see if there's something that's out there that just pops up that says it's a great idea. Someone else had that idea. Don't be wasting your money on it because you'll be infringing on this patent. But often something doesn't pop up in prior art, and you go ahead and you form the company and you file for a patent and you go out there. You don't necessarily know what's out there that you might be infringing. And the way to find that out is to do a freedom to operate search, which is extremely expensive. I don't know any early stage companies that are ready to spend $50,000 doing a freedom to operate search. Now, the investors who come in, who may be putting 20 or 30 million in, I've been on the other side of that freedom to operate search because it's very important to them. And at that point, you kind of hold your breath a little bit because you may not know what's out there. So, I mean, I think you take the proper steps in when you file your patent, and generally you're going to go to experienced patent counsel who are going to help. You're going to assign all the IP, but you may never know for sure whether you're infringing someone's IP. And that'll certainly come into play when you're making representations and warranties to investors or to acquirers about the state of your intellectual property. Do you know for certain that you're not infringing? Probably not. And depending what industry you're in, it's more likely that there could be infringement, especially in life sciences. So you see a lot of cross licenses and things like that. Is that the sort of thing you were thinking about, David?
Yeah.
Yeah, I mean, I've seen companies who have made assumptions about what might be out there, and those assumptions later proved to be wrong. And maybe that was a failure in part by their IP, their patent counsel. And just so you understand, David and I are not patent lawyers. I mean, if you're corporate, you would call us corporate lawyers, or and we do the corporate side of things, and we work with patent counsel. David and David both have them at their firms, and I work with lawyers from other firms who will file the patents. And so so one thing about that just is understanding the distinction between what your corporate counsel does and what your patent counsel does. And I actually have clients, and maybe some who've done it before or a little more sophisticated, and before they come to me, they might already have patent counsel. So, and they've already been talking to patent counsel about, they know they need to file a patent. They've been talking for a while, maybe, and working, maybe they filed a patent already. Although, if they haven't formed the company, then there's an issue. You've got to get all this signed over. But in any event, just understanding how the patent counsel works and getting good patent counsel is equally as important as getting experienced patent counsel in your domain is just as important as getting experienced corporate counsel who have done a lot of startups before and know the ropes.
I think FJ really hits on this. You want to build as strong intellectual property protection as you can. It starts with NDAs. It starts with an assignment of inventions to making sure that contractually you have brought into the company everything that the company should have. But then again, not being patent lawyers, but we all work with them every day, is you can just file a patent, or you can have a patent lawyer who's thinking 10 steps ahead about how you build a moat, if you will, around your intellectual property because of where you think this company might go. That's a very important part. And, the role that the three of us play really is, general counsel to our clients. None of them are big enough to have an in-house general counsel, at least in the early days. And they come to us, and it's our job to think about these issues and make sure that other people are being brought in to help them who have that special expertise. So, you really want to know, you want to feel comfortable that your lawyer understands the kind of issues you're facing and is prepared to help you find those other experts.
Can I follow up on one point you've been making, David? And I think this will be of particular interest of people connected with Pitt and CMU, is that you should understand that Pitt and CMU's patent counsel do not represent your company. Now, they are very helpful. They are representing the university. And so when you have technology that was developed in the university, they are typically going to be filing the patents initially, and they will be doing some of that work in-house, which can be a benefit to you, but you have to understand that at some point the company needs to have its own patent counsel. And even when you don't maybe yet have your patent counsel because you haven't taken the technology out of the university yet or whatever, that just be aware that that lawyer's ethical obligation is to the university that they are employed by and not to, or engaged by, and not to your company. So, and you will eventually need one because there can be times when the company's interests and the university's interests are not completely aligned. I mean, typically they're at the early stage, they're mostly aligned, but then that may not always be the case. And you just need to understand that. And not understanding that is a mistake I've seen.
So, did you happen to see Jill's question in chat?
Yeah, let me just make one more point. I'll get to that. Let me just layer on one more issue, which is that, I mean, to both of your points, it is important to have, I'll call it an IP strategy early on. Because if you don't foreclose opportunities for protection. So for example, there are mistakes you can make early that will preclude you from getting a patent, right? I mean, if you disclose it or you use it, there's other countries don't have a 1-year rule on it. So there's if you disclose it, you lose your trade secret protection. So I always tell people it's very important to have an IP strategy. You don't have to go through it all, but just have a sense of how you're going to protect the IP early on, and have that discussion. I think is incredibly helpful. Let's see, what's the question? Let's see. So I'm not sure I understand the question, but it looks like you're gonna, do you have to assign all IP to the company? And then it looks like perhaps you're considering having the IP in one company and licensing it to the operating company, if I'm reading this right. Right? And so in my experience, for what it's worth,
It's worth a lot, David.
Well,
right.
that's what he tells his clients.
You can try to hold the IP outside of the company, but I think sophisticated investors are going to want the IP in the company, assigned to the company. They want to know that all the assets are in there. Now, we do sometimes have companies that have IP licensed from universities because that's a lot of choice. They're not going to sign it in, but founders, investors want the company, the technology in the company. They don't want, I mean, for example, if there's a problem with that license, they don't want to, they want to know that the asset, I mean, it's like if you're doing a real estate investment, you don't want to lease, you want the property in the company. Similarly, you want the IP in the company. So my reaction is that the IP should be in the company if you're going to try to raise capital.
There are definitely founders, inventors who want to continue to own that IP, license it to several different companies in different domains, and maximize the
Yeah.
exploitation of the technology. I think this is a case of you can't have your cake and eat it too. You know,
Right.
every now and again, someone can pull that off, but in general, they can't.
Right.
The investors say, we want it in, and we want every field of use. We want any use of this technology. That's what we're investing in.
I agree.
Okay, looking at the time here, I don't know if you have one last thing or
I think I'm pretty well done.
any more questions?
Cool. Well, let me thank David and FJ.
Yep.
And Kit. Thank you very much.
Guys,
and
it
if
was
I wanna
great.
thank Stephanie too, David.
If I could
Okay.
interject really quickly, if you could all just take a moment and check out that survey that I posted in chat, that feedback really helps us improve these things. So please. All right.
Okay.
Oh,
So-
we have to sound the cautionary note. I think we do this every year. Good luck to all of you. We've told you about all these mistakes. That doesn't stop you from going forward and doing what you're going to do. Just make sure you get good advice so you don't make them, and you know, and pursue your dreams. It's very
Absolutely.
exciting.